case briefs, and so much more. LSData's got what you're looking for.
In 2004, the United States Court of Appeals for the First Circuit heard the case of Neuhoff v. Marvin Lumber and Cedar Company, focusing on the principle of promissory estoppel. The case involved the Neuhoffs, who sued Marvin Lumber and Cedar Company and Marvin Windows of Tennessee, Inc. for breach of contract, breach of implied warranty, violation of Mass. General Laws H-93A and promissory estoppel. The Neuhoffs had purchased and installed 60 windows from Marvin in 1991, but discovered the windows were decaying in 1994. Marvin replaced 33 windows for free and promised to replace the remaining ones. However, in 2001, Marvin informed the Neuhoffs that their windows would not be replaced for free. The court found that the Neuhoffs' claim of forbearance was not enough to amount to consideration in a breach of contract claim. Nevertheless, it determined that Marvin's promise to replace the remaining defective windows was enough to support a claim of promissory estoppel. The court affirmed, reversed, and remanded the district court's judgment for proceedings. It held that the Neuhoffs had a valid promissory estoppel claim, but their breach of contract and warranty claims failed. The district court and jury determined the Neuhoffs' damages, and each party bore its own costs.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.